Hello and welcome to today's podcast. My name is Malaika Sukhera and I have with me Mr. Raya. How are you?
I'm good, thank you.
Today we will be discussing the 7-year child route. So Mr. Rayaz Anwar, what exactly is the 7-year child route?
So, 7 years child route is one of the areas where we have received numerous inquiries in the past as well. So, appendix private life is something which covers the children, young adults, and adults. Uh, where people have spent a significant time of their life in the UK, so they are eligible or qualified to apply under the private life. As such, you've asked me about the children. So, a child who has spent 7 years continuously in the UK. When they came, they were under the age of 18, and now they have completed 7 years continuous residence in the UK. So, they qualify to apply for leave to remain or indefinite leave to remain under the private life route.
Who exactly would count as a child?
So, anyone who is under the age of 18, when they come to the UK, they are still not living an independent life. They are living with obviously with their parents, and they have spent 7 years in the UK. They are counted as a child in the particular 7 years child application.
And for the purposes of this assessment, does the child need to have legal status for the entire 7-year period?
It's not necessary. The child can have an irregular status, I would say. So, because children who have come with their parents, it may be that the parents had a visa when they came to the UK, but due to some reason they have become an overstayer, so the child still qualified to apply under this route.
And if a child does get a visa under this route, when can this child apply for ILR?
So, depending on, there are two scenarios here. So, what if the child is born in the UK and if the child came from abroad when he was under the age of 18 and they have spent 7 years in the UK. So, if a child who is born in the country and they spend continuous 7 years in the UK despite of their immigration status, whether legal or irregular status, so they qualify for indefinite leave to remain application. And where the children have come to the UK and they have spent 7 years but they were not born in the country, so they apply for leave to remain in that case.
And when is a child eligible for leave to remain?
So, a child is eligible for leave to remain when they come with their parents and they complete 7 years. And once they have completed 7 years, so they have to apply for leave to remain initially. And once they have been granted their visa, first visa for 2.5 years, they apply to extend it for another 2.5 years. And completing 5 years after on this private life route, they are eligible to apply for indefinite leave as well. So, like before, they don't have to complete 10 years now.
In a lot of these cases, one thing that we note in decision letters is the Home Office having a test of whether it is unreasonable to expect the child to leave the UK. What exactly does this test entail?
So, in a landmark case of KO Nigeria, so what the court established in that there are parameters on which the Home Office has to make an assessment, and the reasonableness test is applied on each application. So, when we talk about spending 7 years, that too with the condition that it would not be reasonable to expect the child to leave the country. So, how the Home Office assess that application is that they look at the age of the child. Obviously, they are under the age of 18, and the amount of time they have spent in this country, whether they can speak any other language other than English, how well they have integrated, like in academics, in sports, maybe in community, participation, how much they have done, whether they have any friends or family in this country, in the UK I'm talking about, or how many times they have traveled to their home country or their parents' home country, and how much time they have spent in that country. So, based on that, another factor is also that who they are expected to live with their parents, or if there are no parents, who is going to take the child back to their country. So, all these factors are considered, and based on that assessment, the more time the child has spent, they don't speak any other language, they've never been to their home country, these all contribute to the success of that application.
So, looking at evidence that would need to be provided, can you give some example?
So typically, what people include, or we encourage to include in the application, is obviously child's photo ID, which is passport or birth certificate if they were born in the country, or if they don't have any form of ID. Sometimes we have seen that parents, they just don't make the child's passport. So if they have a birth certificate, we can use that. Their school records, any achievement certificates, or any participation in different events if they have done. So we do include that. To establish their continuous residence, the places where they have lived, or the GP appointments, let's say, or a red book, for instance, if the child is born in the country. So we establish that the child has not left the country, and then we include the factors which can support their application, which may include, let's say, if they have any medical reason because of which which would be unduly harsh on them if they leave the country. So medical reports, social worker report we can also include as an expert evidence, or we can also include any psychiatrist or a psychologist report, depending on obviously the factors which can make an application better. So these are some of the examples, and moreover we can also include any handwritten statements of children or their friends or family members to establish that they have some good social links and their integration is to a level where the removal is going to be harsh on the family and also on the child.
Coming back to what you said regarding the evidence of proving that the child has continuously lived in the UK for these 7 years, do these 7 years have to be continuous, or can a child be away from the UK? And if they can be away from the UK, for how long can they be away?
Yeah, sometimes people, I think it has become a myth now. Some people think that if the child would leave the country at any time, maybe for one day, it will break their continuous residence, but that is not the case. So if a child leaves for less than 180 days in any consecutive 12 months, it will not break their residency. But obviously, to establish that their integration is to a higher degree, they must have spent most of their time in the country. So they can technically leave the country, parents can make the passport, so there is no issue with that.
And another discussion that we had was, when can a child apply for ILR? When can parents apply for ILR under this route?
So the question is, if the child qualifies,
yes,
when the parents will apply for the indefinite leave. Now, depending on their circumstances, what the rules are today is that if the parents had a legal status, they have a regular status, and they have spent 7 years, let's say, they apply for the child gets their leave, and the parents also get leave to remain. Maybe if they have stayed legally throughout and they complete 10 years, they can apply for their ILR. But in a case if their status is irregular and they haven't got a visa at the time when the child gets their first leave, whether indefinite leave or leave to remain, parents will only get leave to remain, and they'll be either subject to a 10 years of spending throughout continuous residence on the private life route. That's when they can qualify for indefinite leave as well, but they will not get indefinite after 5 years, or even the child becomes British. So parents, they are subject to either 10 years or currently, which the long residency route I'm referring to, if they complete 10 years on that.
When we spoke about evidence previously, you stated that part of the evidence would be the child's photo ID. Is there any benefit if a child is born in the UK but the parents don't make the child's passport?
I've heard this question from quite a lot of our Indian national families, because previously there was a case law of MK where people have got nationality based on the statelessness of a child. But since the rules or the Nationality Act has been amended, so making a passport will not, or not making a passport will not either benefit or harm your application. So the parents must go ahead and make a photo ID of the child if necessary.
So child we've covered would be eligible for either leave to remain or indefinite leave to remain depending on their circumstances. What happens to the parents?
So parents, as I said, they get only leave to remain. they keep on extending. 4 times they extend their leave to remain based on the child. Of course, the child must live with their parents so that they can extend. If at any point the qualified child on which the parents have got, makes their independent life, the parents may not be able to continue their leave to remain. So they have to, stick to that family unit to, of course, continue living in the UK, and after completing 10 years lawful residence on this route, they can apply for indefinite leave as well.
As for the child's independent life, what factors does the Home Office assess in taking into account whether a child has formed an independent life or not?
So, if a child, let's say, leave their family home and they've started working elsewhere and they've not been part of the same household, unless they are into education and parents are living in a different place and the child is living and studying in a different place, they can provide the evidence that the parents are paying towards their tuition fee, the child's maintenance, etc. But in a case where the child has not been in education, they have started working, and there is no evidence that they live in the same household, that's when it will be difficult for anyone to prove that the child is still part of the same house and the child is still a dependent child.
So, say if someone got leave to remain on the basis of the sponsor child who has now formed an independent life, again it comes back to what would happen to the parents.
So the parents may not be able to extend, I said, so they might have to choose a different route. Let's say they switch on to a skilled worker route maybe, or any other qualifying route on which they can apply and get a leave separately. So they might have to change a different route, but they cannot keep on extending it because there will be no evidence to support or back their application.
What is the cost for a 7-year application for a child?
The cost as is concerned, so there are two options. One is if you're paying the fee, or one if the scenario is you haven't got any monies and you want to apply for the fee exemption. So if you have the fee, so the standard duration of this visa is 2.5 years, as you know, and the child's IHS is £776. So multiply by 2.5 times, so that is their IHS fee. And apart from that, the visa fee is around £1,321, as I remember. So they have to pay that fee. And if they want to go for a priority service, so there is an additional £1,000 for the super priority service if they want to get the visa granted within 24 hours on a fast track service. So that is only for the child. Parents, they are subject to their own separate fees. But if they don't have monies and they can prove that they have money but they will become destitute if they will pay that fee, so they can apply for a fee waiver and they can get exemption of the whole fees, even IHS and visa fee they don't have to pay, but there will be no priority service for them, so they have to go on a standard application in that case.
What happens if the application gets refused?
So typically in human right applications, if that is on merit application, not out of merit or frivolous application, I would say. So in that case, the family will get the right of appeal, the child will get the right of appeal, and obviously appeal can be lodged within 14 days, and the court then has to decide what are the merits of this application, and if there are any shortcomings, the parents can also include further evidence which they were not able to include at the date of application when they initially applied. So we've seen in the past as well that the trend was to refuse applications back 10 years ago, and the same trend has now we have seen in some examples where people have contacted us. So Home Office is now starting to taking a higher scrutiny on these applications. So if the application gets refused, we can help the applicant with the appeal matters, and the appeal success rate is really high in such cases.
And if ILR is granted to a child, when can they apply for British citizenship?
So generally it is after 12 months. So once they have got the indefinite leave, they have to wait for 12 months in order to qualify for citizenship application. So the child need to be registered. So some people think that they need to naturalize. Naturalization is only for adults basically. So the child has to be registered as a British citizen. So there is an application form which is known by MN1 application. So the parents need to pay the relevant fees and they can register a child as a British citizen.
Thank you for that. Thank you for joining us today. These were the questions that we have been asked the most recently. Stay tuned for our next episode and don't forget to follow us on our social media pages.
Thank you.